Yes. So we are extremely honored to have Dr. Aditya Sondhi with us, who is the keynote speaker for this event. Dr. Aditya Sondhi is a senior advocate at the Supreme Court of India and a towering figure in the legal fraternity. With his profound expertise and notable contributions to the constitutional and appellate law, Dr. Sondhi's perspective adds unparalleled depth to today's discourse. Dr. Aditya Sondhi, being a senior counsel practicing before the Apex Court, he appears before various high courts as well and has served as the Additional Advocate General for Karnataka from 2016 to 2018. Dr. Sondhi has graduated from the prestigious National Law School of India University and holds a PhD from the Mysore University for his thesis on civil military relations in India and Pakistan, which is the basis for his latest book, Poles Apart. He has previously published two books of non-fiction with Penguin, Unfinished Symphony and The Order of the Crest. He has written and spoken widely in India and abroad and has a particular interest in military history, partition, and constitutionalism. It is an absolute privilege and honor to have your presence in this event, sir.
Thank you, Aryan, for that introduction, and also thank you for your efforts in reaching out to me and making this lecture a possibility. Prashant, Manu, my advocate friends, students, and other friends online. Aryan, in fact, mentioned my latest book, Poles Apart, and I'm going to begin with that this evening. 26th November is of late remembered more for 26/11 and the unfortunate incidents of Bombay. But going back in time, it's red lettered because it was really the birthday, if you will, of our Constitution, when the Constitution was adopted, adapted, and was to take effect 2 months later, that is on Republic Day 1950. But there is equally a day in the history of our neighbor, that is Pakistan. And remember, a country that was formed by the drawing of the Radcliffe Line, and a date which is 28th November 1954, a few years after our Constitution came into force, which was the date on which emergency was imposed in Pakistan. And many have said that was the day democracy died in Pakistan. So you have a birthday, and soon after you have an unfortunate funeral announcement almost of democracy in Pakistan. And this is really what my book is about. Of course, it looks more at the incursions made by the military in Pakistan to usurp democratic space, and as to how that has not happened in India. I'm not going to go into those elements. But I believe that when we're reflecting on 75 years of our Constitution, we have to look at it in a sense comparatively. And what better or sharper comparison can we make than to look at our immediate neighbor who was, in fact, born practically on the same day. And the reason this date of 28th October 1954, as I said, is regarded as the death knell of democracy is not just that emergency was imposed. Please remember, we had emergency as well in the 70s. But in Pakistan, that was the starting point from where the military came into political power, leading to martial law and leading to a recursive pattern over its history, where for over 50% of its existence, there has been direct martial law. And over the remaining 50%, I would say, dare say, has been indirect martial rule, martial interference. And even today, if you saw the reports breaking, There have been shoot at sight orders declared because of supporters of Imran Khan being out on the streets. The situation in Bangladesh is not very different because of the political instability that is prevailing there at this point in time. And these sharp outcomes in our neighbors and relatively our better experience with democracy, in my opinion, lies significantly on account of the fact that we have had a commitment to the Constitution early in our history. There are other reasons, no doubt. But as I said, when you reflect on 75 years of the Constitution, please celebrate firstly the fact that we made this intuitive commitment to a Constitution very early on. Even 1949 was really the culmination of the Constituent Assembly's efforts. The idea that we would be governed constitutionally was something that was built in to our very identity from day one. And that is a crucial reason as to why, despite many aberrations and challenges over the past 75 years, we have by and large been able to return to a status quo within the parameters of the Constitution. Even the emergency that we saw in the 70s was imposed constitutionally. It was never challenged before the Supreme Court. And B, the political outcomes thereafter, again, were largely electoral. Of course, the abuse of power, the imprisonments, the violence, the violation of fundamental rights at that period remains a dark chapter in our history. But I am encouraging you today to take a longer view of our history. After all, it is 75 years that we are discussing today, and contrast the fact that had we not committed to this idea of India under a constitution early on, we could have gone any which way. The fact that in Pakistan it was the military that usurped power, that in Bangladesh there have been periodic phases of military rule, and now this so-called caretaker government, ad hoc, calling the shots, are of course extra constitutional and unwelcome developments. But the fact is that these developments tend to take place when your commitment to the Constitution and your constitutional traditions are not strong enough to insulate society from all these sorts of outcomes. So, really, friends, the vaccine, as I've often called it, that we have against ad hocism, against extra constitutional usurpation of power, remains our Constitution. And therefore, it is for us today on the 26th to cherish and to nurture our engagement with this Constitution, and especially for you as young citizens and as young potentially practitioners of the law. The Constitution, I hope, will be your watchword and will be something you acknowledge for its historic and its historical background. It is, of course, the longest and the most amended constitution, with 395 articles, with as many as 12 schedules, and if I'm right, 105 amendments, including more recently the GST and the economically weaker sections reservation, EWS, which were amendments that were brought in to the Constitution. A constitution naturally must grow and evolve, and in a complex and diverse society such as ours, all the more there is need for amendment to take place from time to time. But that's not to say our experience with amendments over the past 75 years has always been kosher. You are all too well familiar with the basic structure doctrine and the fact that the Supreme Court has from time to time, in fact, been required to strike down amendments to the Constitution that have been found to be violative of this fundamental structure or basic structure of our Constitution. Again, for me, this is a matter that requires to be re-emphasized that you have been able to achieve a jurisprudence where the constitution is not necessarily its black and white letter, but it is really something between the lines and in a way behind the lines. The basic structure is not something that the constitution even makes mention of, nor does the constitution make mention of the collegium, nor does the constitution say in so many words that we are a parliamentary form of government and not presidential. If you were to read the constitution as a layperson, you would get a very different impression of what the constitution is and how far it can be amended, and how, as a result of the constituent power, parliament has an almost carte blanche to amend the constitution and practically rewrite it. But we have, through our jurisprudence, through the efforts of lawyers and judges, and I'm happy that Manu is going to be speaking to you later about Nani Palkiwala, one of the architects of the basic structure doctrine. And this arm wrestle has been achieved not easily, but we've come to a position where today the constitution at many layers is sacrosanct and therefore beyond the reach even of parliament. Of course, I have argued recently that this basic structure doctrine itself is not something one can take for granted. It was, after all, a 7:6 judgment in Keshwanand Bharati that gave rise to the doctrine, and who knows whether that can be subjected to judicial review by a larger bench in the days to come. But that said, you are at least, you and we are at least in that position of comfort that we know that today you have this doctrine defining and guarding the constitution. And I don't have time to go into the details of the many facets of the basic structure, but as you know, there are so many which are fundamental to us as individuals. The preamble, democracy, secularism, federalism, judicial review, independence of the judiciary, so on and so forth, fundamental rights, directive principles, unfortunately not given their fullest effect. But remember that this is not a status quo that everyone is happy with. Just yesterday, you must have heard that the Supreme Court rejected a PIL where there was, believe it or not, a challenge to the inclusion of socialism and secularism in our preamble. And the challenge was on account of the fact, inter alia, that these words were introduced in the preamble subsequently. That, of course, is a hyper-technical argument. But it tells you that there are credible and serious factions in society who are not comfortable with the constitution even having these words. Socialism has been under attack in a different way because of the more recent judgments where Justice Krishna Iyer's jurisprudence was commented upon to an extent. Prashant will know all too well about that. To say that you don't want secularism in the preamble suggests to you that there are two Indias in a way. There are two perceptions of India. Those who believe that the constitution is the last word on our identity, and those who believe it's not. So therefore, as much as I said, we need to celebrate at this point the path that we have taken constitutionally for 75 years. Everything is not kosher. The challenge, or rather the turmoil over which India is to prevail, whether the idea of India must fit into the constitution or the constitution must fit into the idea, that friction is well and truly on. And for you as young lawyers, you're actually going to be budding young lawyers, you're going to be stepping into the profession, for those of you who choose to practice, where these conversations and these arguments and these decisions are going to be made, and many of these are going to be defining for us. And therefore, there is a greater reason for you today to take stock at 75 and say, look, we've done well to get here, but then there's still a lot of work to be done. That said, no constitution is perfect. Our constitution has had amendments, as I said, that have been struck down, the NJAC, etc. There have been amendments that have taken us further. For example, the right to education, the very interesting provisions. In fact, I'm in Hyderabad at the moment for a case involving reservation, and you're all too well aware of the special provisions that have been inserted in the constitution for special rights to be created in more backward districts in Karnataka and Hyderabad, Article 371D, 371J. That's been the march of the law. But there are still voids to be filled. Justice Cameron had of the South African Supreme Court, and a great legal scholar, had said, there are schools of thought, those who believe that the Constitution does too little and some who believe that it does too much. But the truth perhaps lies somewhere in between. And there are vacuums that need to be filled in our Constitution, I believe, partly to the extent of having some of our rights better defined. For example, as much as it is to the credit of our system that we have been able, when I say we, I mean really the Supreme Court, has been able to interpret articles, especially Article 21, broadly enough to cover many, many unsaid rights, the right to ecology, the right to privacy, etc. But the difficulty there is that when these rights are not codified and spelled out in the Constitution, it's still a matter for interpretation, and it's up for grabs. And perhaps it's time for us to reflect on whether we need, not exhaustively, but illustratively, to codify in our Constitution some of these very important socio-cultural, economic rights which have been recognized by judgments of courts to be available to us as citizens and as individuals. I have myself argued a case up to the Supreme Court with respect to the absence of any constitutional regime over India's intelligence agencies. And I think my colleague Nidhi Shri is here. She assisted me most ably in that matter. And that opened up my eyes to say that while we celebrate our being a constitutional liberal democracy, there are still these dark spots. To have intelligence agencies not even mentioned really in the Constitution except for a stray reference in Schedule 7 tells you that there's work to be done. But perhaps most importantly, and this comment of mine comes on the back of a lecture that I did at Oxford University about 2 weeks ago on the death penalty jurisprudence in India. And I argued that we have been practically abolitionist when it comes to death sentencing in the Supreme Court. And for those of you young scholars who've been following these judgments, you will see that the Supreme Court rarely awards death. Even the rarest of the rare has become most rarest of the rarest of the rare. And that is on account of many principles of mitigation, etc., etc. I don't have time to go into that. But as much as the judicial side has moved towards being abolitionist, the legislative side is anything but that. We have in fact been increasing the number of offenses in which we have chosen to build in the death penalty. And the recent new criminal laws are an example of that. We have jumped to, I think, 14 or 16, not to mention the many special enactments which have the death sentence. You know of the Aparajita bill in West Bengal, where death has been introduced for rape. Of course, it's awaiting presidential assent. So we're in that. And look, I'm singling this out as an example, not simply because I had a chance to speak on it and I do some work in this area. I'm speaking about it because at the end of the day, death sentencing is something central to your criminal jurisprudence. And it's literally a matter of life and death. All conversations about Article 21, etc., have their place. And then there is the right of the state to award death of course, through the process of the court. And that debate is ongoing. And many countries, many countries, I'm forgetful of the number now, but a majority of countries worldwide have moved towards abolition. Again, de facto, de jure, in different forms. Some have abolished it for all offenses but terror. That's besides the point. The point I'm trying to make here is that there are countries, many, where constitutionally amendments have been brought doing away with the death penalty. And the reason for that is that you then elevate this, this conversation around death sentencing to a much higher level. As I said, even constitutions can be amended. But once this is built into the constitution, the scope for a rethink, for executive orders, for legislative amendments, and even for judicial opinion to tamper with this status quo becomes far more difficult. But this remains one of those voids. Of course, I don't see this being addressed. If anything, the inkling clearly is that while courts are moving towards a sort of abolitionist jurisprudence, parliament, legislature, and the executive are actually pulling in different directions. The other great challenge which occurs to me when we're reflecting on our 75th birthday, as it were, is the challenge to the rule of law. And I hope that this is something all of you take with utmost seriousness, because this is a challenge not just philosophically or legally for practitioners. It's a challenge for every citizen. It's a challenge for every individual in different ways. Of course, many of us are more privileged and possibly in that sense more insulated from abuses of rule of law. But that doesn't mean we turn a blind eye to it. And the recent judgment on so-called bulldozer justice, it's an oxymoron, that was delivered by the Supreme Court reinforces this point. And it's a very readable judgment by Justice Gawai and Justice Vishwanathan's bench. And I hope you will all read it, write on it, discuss it. It, in many ways, states the obvious, which is that the culpability of an individual in criminal law and the due process which is to be followed in that direction can really never overlap with the material assets that an accused or a convict owns or their families own. And there can't be double jeopardy, there can't be multiple draconian punishment, and worst of all, there cannot be an abuse of rule of law where you walk in and demolish somebody's house, or often on suspicion of them being involved in criminal offenses. This is really the central point. And this is where I think the judgment goes beyond the obvious, because it states that in doing so, it is really the executive usurping judicial function. I said to you earlier, judicial independence is part of the basic structure. That judicial independence necessarily means that decision making is by courts, by constitutional courts, not by paralegal courts or extra legal courts and institutions. And if the executive, when I say the executive, it really means a district magistrate or a municipal officer or commissioner, depending on which local law is being applied, deciding for themselves that this property belongs to somebody who is culpable and punishable in criminal law. How bizarre is that? When you require a full-blown trial to take place in a criminal court subject to appeals, revisions, SLPs, etc., can you have an executive non-judicial officer deciding indirectly as to who is to be punished? And though, of course, the executive may not punish through imprisonment, the executive punishes through demolition and dispossession. And of whom? Not just an accused, of the accused's wife or spouse, children, parents, assets. And it's a poignant judgment because it also talks about what ultimately a home means to those of our fellow Indians who have hard-earned homes and small roofs over their heads. And these are usually the people who are at the receiving end of this sort of justice or injustice, if you will. So these challenges to the rule of law are galore. You know of extrajudicial encounters, what people call fake encounters, which are being celebrated in society. Again, jumping the gun. Um, all of this, friends, is a slow poison that eats into the spirit of the Constitution. And it also reminds me of the recent judgment of the Supreme Court on caste-based segregation, or may I say caste-based discrimination within prisons in India, where a former junior of mine, Disha Wadekar, she in fact led that case in the Supreme Court, and the Supreme Court held that the prison manuals subsisting even in 2024, which provide for menial jobs, cleaning of toilets, manual scavenging, etc., to be done by prisoners based on their caste. And the fact that the Supreme Court had to declare that as impermissible in 2024 tells you that as a society we have a long way to go before we can develop a constitutional spirit. So that returns me, friends, to the point that I earlier made, that in some ways we have two Indias. I have a podcast that I run called The Podcast, which is conversations around caste, where I have often 10 episodes so far spoken to 10 most interesting subjects where my guests have been through such extraordinary life experiences. Many of them are well placed, lawyers, artists, etc. But they tell me, and they will tell you if you tune in, as to how real caste is in Indian society, and the sort of subtle and often not so subtle discrimination that we face or we perpetuate even as we speak today. And these are the sorts of poisons that we have to resist against, we have to fight against. That's a fight we have to take up socially, we have to take up personally. Many times we have to take it up with our own immediate community, with our family, with our friends. But it's also a fight that you have to take up as budding young lawyers, as scholars, as practitioners. And I remember when we had joined the National Law School in 1993, Dr. Menon, Dr. Madhav Menon, with whom my friend Prashant was closely associated, he had at our orientation, made a clarion call to us to become social engineers. I still remember those words. I've publicly credited that speech as having driven me to try and do something in my small way as a lawyer, first and foremost to become a practicing lawyer, because he planted that thought. I had never heard that phrase before, social engineers. And it's a very, it's a very imaginative and a very creative phrase to use. And in many ways, when I made this comparison with Pakistan and Bangladesh, a great deal of credit must go to the social engineers who have engineered the architecture of our constitution. As I said, it's not Article 1 to 395. It's between the lines. It's the creativity that has led to a jurisprudence where we've reached a stage of a very, very healthy constitutional tradition. Remember, traditions also require implementation. But there is social engineers, have been largely lawyers, like Manu will speak to you now soon about Mr. Palkiwala and many others. But I believe now, where we are at this moment in our history, and I had said this at the inauguration of the School of Law and Justice that is upcoming in Bangalore next year, whose board of advisors I happen to be the chairman of. And I had said at that inauguration that now we have to speak not merely of social engineers, but we have to speak of social healers. Because we've reached a stage where Yes, that engineering, that creative interpretation of basic structure, Article 21, gender rights, human rights, intersectional rights, etc., very, very important in their own right. But we've reached a stage today where in many ways we need old school lawyering. And I can tell you this from experience, how important is bail, how flooded is the Supreme Court with bail petitions. Of course, at the heart of bail is Article 21. But a great deal of work and a great amount of time is being spent in courts on these old school rights determinations. Bail, protection against dispossession, protection against lynching, protection against uh, persecution, the breakdown of rule of law and order. These, if I may say, these are old school problems in a way, which require old school advocacy to simply try and enforce the law as it stands. Of course, the law marches on, even with bail. Many of you must have seen how judgments have developed bail jurisprudence. Even stringent acts like UAPA, PMLA, etc., which make bail practical impossibility. Courts have said Article 21 prevails over these statutory provisions where there is an inordinate delay, not on account of the accused conduct. Then that delay itself vitiates or violates the rights of the under trial, and therefore bail becomes a rule. Of course, it's an everyday battle for accused who are in custody. So, for you folks who are going to get into the practice of the law, I would like to see you approach it in many ways as healers. You're going to be healing in many ways parts of broken society. Uh, this is going to advance the rights and interests at a very basic level. The very basic level of a right to dignity or a right to a free trial, or for that matter, the right to liberty, are going to be the areas of practice that you might find yourself returning to. And you have an important role to play there. You heal in many ways. You actually heal the fractures of society. Of course, you will be also walking into a complete new age practice. That's the diversity in a way of where we are, the two Indias. You'll be walking into AI and high tech and competition law and cyber law and space law, all of which are charming and most interesting in their own right. But remember that there's a great deal of room for you to play a role, even in the more conservative and traditional types of practice. And those are going to pose their own challenges and provide you with tremendous opportunities as we move ahead. Ultimately, friends, I will have to close shortly. I have a flight to catch. But I would end on a note where I very sincerely, call upon you, beseech you all to try and conserve and protect the Constitution. It's under attack in many ways. As I said, for me, it's ironical because my book is largely about how our commitment to the Constitution has made us different, certainly from our immediate neighbors, and in many ways different from many other countries. There's a recent article that went out, I think, this morning on the leaflet about how the basic structure doctrine itself has been applied in many jurisdictions in the world. So we've exported that good law, but the Constitution nonetheless remains under challenge from within and from without. And that's where you have to see this as a creative and a collective document, not merely as a colonial or a communal one, as some have called it. There are other potshots also taken at it. Fair enough. That's the charm of our system. There's room for thought. There's room for many schools of thought. But that said, there is a certain core spirit to our Constitution. And if some of you get the chance to watch my talk on the Constitution and the idea of India, I've argued that in many ways, and I speak for myself, our identities are developed basis the Constitution. A Constitution that Baba Saheb foresaw as being an equitable Constitution above all else. So that's where your role comes in again, to conserve it and to preserve it. And ultimately, today is a birthday. So we're celebrating the 75th birthday, if you will, of the Indian Constitution. But as we often know, people remember us all day on our birthdays and then forget about us for the next 364 days. At least that's the case with me. But it's not enough to have this blitzkrieg on the Constitution today. It's amazing in a way. Everywhere I go, I see celebration of the Constitution, talks, events, documentaries that you saw, friends, just status updates tells you that people are happy to celebrate this day. But it's not enough. We have to keep this celebration and we have to keep this engagement 365 days a year if we're really to build on this wonderful constitutional ethos that we have developed. So with that, may I thank you very much for inviting me to deliver this lecture, and I wish all of you the very best. Thank you.
Thank you so much. It was an honor and delight to have you.